Imagine you're preparing to go on a big vacation, and so you decide that you've got to put your estate plan documents together. And you've also decided that the revocable trust is the way for you to go. So you meet with us, you sign a revocable trust document, you retitle all of your assets in your revocable trust, so you're all set to go on your vacation. You head off on your vacation, and while you're there, you find some lovely property, and you decide, I'm going to buy that property. But you forget that you are the trustee of your trust. And you buy that property in your individual name. You don't think anything of it. And so you live your life, go on your merry way, and during that time, something bad happens, and you wind up dying. Your family comes to us, and they bring the lovely estate planning red leather binder with them, and they say, oh, well, Dad took care of everything. Everything is just the way you said, and we don't think we ever have to go to probate. Unfortunately, the bad news is you have out-of-state property in your individual name at the time of your death. And what that means is we have to start a probate proceeding in the state of Florida and an ancillary proceeding in the state in which you bought that property in your individual name. I'm Barbara Pizzolato, and I help people manage the rest of their continued living. Over the next few minutes, I'm going to tell you how you can avoid probate, first in the state of Florida, and an ancillary probate in another state, so that you don't have what happened to those people happen to you. The problem with owning property outside the state of Florida in your individual name is that people forget that the law of the state in which the property resides will control what happens with that property. And so the state of Florida has no jurisdiction over that property. And the only way your family, once you're gone, can gain access to control that property, whether they want to keep it or not, is if somebody through the probate court gets appointed personal representative. And so that's why they're in a position where they have to go through the longest proceeding, it's called a formal proceeding, in the probate court to be appointed, and then they have to start another proceeding in the state in which the real property is located to have the documents the Florida court provided to them recognized jurisdictionally in that other state. Once they are appointed the personal representative or executor, the documents in Florida are recognized for the authority, they will now have authority to sell or to rent, do whatever they want with that property in the other state. The easiest thing to assure that that doesn't happen, of course, is if you initially buy the property in your name as trustee of your revocable trust, or if you have forgotten to do that at the time, let counsel know and we will retitle that property in the name of your trustee of your trust. That is the easiest way to avoid this. Key to this for our clients, of course, is participating in our family care program, because our family care program is geared to reviewing your plan on a biennial basis. And so if something comes up where you forgot that you bought property in Nova Scotia, we can assure that that property gets titled in your revocable trust. One more thing to consider is if you have owned property either outside the state of Florida or even in Florida, is if you've owned that property for a very, very long time and you're a married couple, you might want to consider retitling that property into the new Florida Community Property Trust, because you have the opportunity on your date of death to get a double step-up in basis. I'm Barbara Pizzolato. I help people manage the rest of their continued living. Let us help you.